Hi guys, it's Professor Moore recording a review of the second week of civil procedure. I hope this helps, and if you have any suggestions for how I can make these review videos more helpful, please email me. Thanks. So we're going to pick up with the amount in controversy requirement. We were talking about federal subject matter jurisdiction, and the first type of subject matter jurisdiction that we looked at was diversity jurisdiction under 28 U.S.C. 1332. And the last video was really about what it means to have diverse citizenship, or citizens of different states, or citizens of a state versus a citizen of another country, etc. This week we focused on the second requirement for diversity jurisdiction under subsection A of 1332, which is that the amount in controversy must exceed the sum or value of $75,000 exclusive of interest and costs. Most cases that are filed in federal district court have no problem meeting that requirement, but there are some cases at the margin, and so we'll discuss what needs to happen in order to meet that amount. First of all, as those of you that took that little quiz question at the beginning of class, I forget when, you know, since it was a trick question, that the amount in controversy cannot be exactly $75,000. It must exceed it, exclusive of interest and costs. Sorry, I had to adjust the PowerPoint so it wasn't off the screen. So this issue came up in the Moss versus Perry case, where Mr. Moss claimed damages of more than $10,000, which was the amount in controversy at the time. Of course, today it's $75,000. And this was the memorable case about their landlord, Mr. Perry, spying on the Mosses in their newlywed months. So after a trial, the jury awarded Mr. Moss $5,000, which was something, but it was less than the amount in controversy at the time. And so Mr. Perry, who was claiming after he lost that there was no subject matter jurisdiction, said, well, you didn't have the amount in controversy. And so the first question is, does the fact that the plaintiff is ultimately awarded less than the amount in controversy mean that there never was the amount in controversy and the court loses jurisdiction? Well, just to pose the question indicates the answer, which is no. As we learned, we decide whether we have the requisites for diversity jurisdiction on the date the complaint is filed. And so we look at whether the amount in controversy is met on the date the complaint is filed. And in order to meet that, to satisfy that standard, the amount claimed by the plaintiff in their complaint in good faith controls whether you've met the amount in controversy. However, there is an objective quality to good faith. There has to be sort of a legal basis for the damages to go over $75,000. It doesn't mean that they must go over $75,000 necessarily, but it means that they could in a rational world under the law as it exists now. So the St. Paul Mercury test, which was referred to in the Moss versus Perry case and also in that other removal case that we read, it says that the amount claimed by plaintiff in good faith controls, but if the plaintiff's so-called good faith meets the objective test to the degree that it appears to a legal certainty that the plaintiff could never recover over $75,000, then you don't meet the amount in controversy requirement. So with Mr. Moss, he was claiming damages for a tort, probably intentional infliction of emotional distress, although we're not really told. The damages are, not set in stone. They're kind of personal, and At the time, it wasn't possible to say that he wouldn't have collected more than $10,000. So it couldn't be shown to a legal certainty that he could not have ever recovered more than the amount in controversy. And so his good faith claim of over $10,000 sufficed. So here is a hypo where the amount in controversy would not be met. So imagine that instead of the real case, what the case is about is that Mr. Moss, at the beginning of their lease, paid Mr. Perry a $2,000 security deposit. And at the end of their lease, Mr. Perry, of course, refuses to return it in violation of Louisiana state law. So Mr. Moss sues Perry in federal court, and I'm sorry some of that's cut off again by my face. He sues Mr. Perry in federal court claiming $100,000 in damages, $2,000 for the unreturned security deposit, and $98,000 in punitive damages. So in good faith, he feels like his stress and aggravation in not getting that $2,000 back should be, Mr. Perry should be punished for that in the amount of $98,000. Well, unfortunately for Mr. Moss meeting the amount in controversy requirement today, Louisiana state law does not allow for punitive damages in the withholding of a security deposit. In fact, I doubt any state does. And actually, I'm just making that up about Louisiana law. I don't know for sure that it doesn't, but I would bet money that it doesn't. Because typically the state law is that you can't get punitive damages on a breach of contract action. So the law prevents Mr. Moss from getting those punitive damages, and therefore, even though he had subjective good faith in saying, really, I feel like I was damaged to that amount, or that Mr. Perry, should be punished to that amount, under the law in Louisiana, the only amount he can ever recover is $2,000. And so you can prove to a legal certainty that Mr. Moss will not meet the amount in controversy requirement in this hypo. Now, okay. We also went over in class this part of subsection 1332B, which addresses the situation of the plaintiff initially stating a correct amount in controversy, the requisite amount in controversy, and then the plaintiff ultimately wins something, but it turns out that what they win is less than $75,000. So first of all, you don't lose subject matter jurisdiction. We know that from Moss versus Perry. But 1332B says that in that case, the plaintiff might not be allowed to collect his costs from the defendant, and he may in fact have to even pay the defendant's costs. Costs in this case does not include the big ticket item of attorney's fees. So other ways of meeting the amount in controversy requirement. How about aggregating claims? So let's say Mr. Moss had a claim for $30,000 and Mrs. Moss had a claim for $30,000. Can we put those together? Well, of course, even if we added those, it wouldn't equal $75,000. But even if Mrs. Moss's was $50,000 on its own, so that it totaled $80,000, it still would not work for meeting the amount in controversy requirement. So separate plaintiffs with separate claims for damages cannot aggregate to meet the amount in controversy. Now, we will see kind of a variation of this where later on in the semester where one of the plaintiffs does in fact on his or her own meet the amount in controversy requirement, and then the question is, what about other plaintiffs that don't meet the amount in controversy requirement? Can they tag along to the one that does, and we'll address that question later. Sorry, that slide's out of order. Okay. How about this hypo? The plaintiff sues the defendant for $70,000 for personal injuries in an accident and $15,000 for an unrelated breach of contract. The plaintiff and the defendant are citizens of different states. Is the amount in controversy met? And the answer here is yes. So one plaintiff can aggregate all the claims she has against one defendant, even if those claims are completely unrelated. So that was our brief rush through amount in controversy, and we've reached the end of diversity jurisdiction, except to the extent that it was picked up again when we did removal. So we then turned our attention to the other major type of subject matter jurisdiction that we're going to study, which is federal question jurisdiction. And this is the jurisdiction that is granted to the federal district courts by the statute 28 U.S.C. 1331, which reads, "The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States." And as I said in the other video, the Constitution, laws, or treaties of the United States is just about always abbreviated to federal law, giving us the expression arising under federal law. Note that there is no amount in controversy requirement if your claim is based on a federal question. I mentioned this other video. I think I have it in the syllabus. I'm not going to go into the points that were made in the introduction video, so if you want to either watch that one for the first time or look at it again, there's the link. Okay. So let me do a schematic here that seemed to help a couple people that came in to ask me questions during office hours. So at the top is a box that's called the subject matter jurisdiction of the federal district courts. Sometimes this is abbreviated or called colloquially federal jurisdiction. And that's a name for the whole shebang, the subject matter jurisdiction of the federal district courts. As I said, there are two major types of subject matter jurisdiction that we studied. One is diversity, one is federal question. You only need to satisfy one of those to get into federal district court. You do not need both. Some cases coincidentally have both, but you don't need both. Here's a multiple choice question. I'll give you a chance if you want to pause the video. Somehow, every time I do this, the slide automatically goes to the next slide, which has the answer already marked. So, it's not a surprise. The correct answer is C. There is subject matter jurisdiction here. This is a simple illustration of federal question jurisdiction. The plaintiff manufacturer is claiming a violation of the Federal National Labor Relations Act. And so at this point in your career, you may still be struggling to distinguish federal law and state law. When you see these questions, the word, if I write the question certainly, the word federal is going to appear in front of the name of the statute so that you will know it is a federal statute. So when you see Federal National Labor Relations Act, you know that that is a question arising under federal law. That is the federal law on which the manufacturer, the plaintiff, bases its claim. So the red herrings about diversity jurisdiction should be ignored because you don't need both diversity and federal question. You have federal question. There is usually concurrent jurisdiction between the state courts and the federal courts over federal questions. In other words, a state court usually can go ahead and decide something that is based on federal law. However, there are some claims under federal law that are reserved exclusively to the subject matter jurisdiction of the federal courts. If I am to test you on one of those, I will very probably say that jurisdiction is exclusive in the federal courts, which means that the claim cannot be brought in state court. If a question does not say that, here are the most commonly known examples of claims which are exclusive to federal court: admiralty, bankruptcy, copyright, patent, federal antitrust law, and federal securities law. All right, so again, looking at that question, what does it mean to have a claim arise under federal law such that you satisfy federal question jurisdiction under 1331? We get a little bit of a twist on it from Louisville and Nashville Railroad Company versus Motley. And we get out of that the well-pleaded complaint rule, which the court never actually uses that term, but that's what it's called. And so what that means is that in order to interpret 1331, we're going to see whether the plaintiff's own cause of action necessarily refers to federal law or necessarily relies upon federal law for his or her claim. Remember, in the Motley case, the Motleys were suing the railroad for breach of contract for not honoring their lifelong railroad passes. And the railroad said, well, but, there's this federal law that prevents us from doing so. And the Motleys actually said that in their complaint. They said, the railroad is not giving us the passes because of this federal law. And the Supreme Court said that will not suffice to make this a federal question case. The plaintiff's cause of action here is breach of contract. There is nothing in the essential elements of breach of contract that requires the plaintiff to be talking about federal law. Breach of contract is a state law claim. There's no requirement in stating a claim for breach of contract that you say why the defendant breached the contract, even if that reason is because they say it would violate federal law. So anticipating a federal defense that might be raised by the defendant, in other words, is not going to work to bring the complaint within federal question jurisdiction, or bring the case within federal question jurisdiction. Even if the defendant goes ahead and actually asserts a federal defense in his answer, that is not going to suffice to create federal question jurisdiction. Even if the defendant files a counterclaim against the plaintiff and the counterclaim is based on federal law, that will not suffice to bring the case within federal question jurisdiction as that has been construed under 1331. It is the plaintiff's own cause of action which must necessarily refer to federal law. Now, we talked briefly about how there's a relatively recent statute, 28 U.S.C. 1454, which makes an exception to that counterclaim rule for cases based on, for counterclaims based on copyright, plant variety protection, and patent law. So here is another multiple choice question, again, that I'm having trouble getting within the screen. So I'll give you a second to read this one. I'm going to read C and D for you because I can see that it's somewhat cut off. The answer to C is yes, because the fishing company will rely on a federal statute, thereby making this a case arising under federal law. And D is yes, because federal courts have exclusive jurisdiction over cases arising out of environmental statutes. So I will give you a second to pause the video and read that and decide what you think the correct answer is. And the correct answer here is A. No, the federal district court does not have subject matter jurisdiction because the case does not arise under federal law and the requirements of diversity of citizenship jurisdiction are not met. This case is pretty much exactly like the Motley case, where we have a contract and the defendant is failing to perform the contract and using the passage of a federal law prohibiting performance as its excuse for non-performance. This is not sufficient to bring the case within 1331 arising under federal law, as that has been construed by the Supreme Court in Louisville and Nashville Railroad versus Motley. So this case does not arise under federal law. Now, a very tough variation on this involves how do we treat this if we turn this around to be a declaratory judgment action. So, as we discussed, there is a federal statute, 2201, that allows parties with a live dispute to bring that dispute into federal court if they otherwise meet the requirements of federal subject matter jurisdiction, and simply ask the court to declare the legal rights and obligations of the parties to that dispute. So if we had a case based on a breach of contract like the last multiple choice question was, the natural plaintiff suing for breach of contract here was the importer, who was the one claiming that the fishing company had failed to perform. So the importer is the one who has the right to claim damages or ask for an injunction against the fishing company, ordering the fishing company to comply with the contract. Those two types of relief, damages and injunctive relief, are sometimes referred to as coercive relief. What the federal declaratory judgment statute does is that it allows the person who really wouldn't be the real plaintiff seeking coercive relief to go ahead and become a plaintiff. So in a declaratory judgment action, we could have the fishing company being the plaintiff, saying, please court, here's our dispute. I'm saying I don't have to comply with this contract because federal law now prohibits me from doing so. Please tell us what the rights and obligations of these parties are under this contract. So now it looks like we do have an honest-to-God plaintiff necessarily referring to federal law in its complaint. But the Supreme Court has said that in order to determine in a declaratory judgment action whether there is subject matter jurisdiction, what you have to do is you have to pretend that the case is really one in which the plaintiff is the plaintiff who is suing for coercive relief. So you imagine who would be the party here who could sue for damages or who could sue for an injunction. And that will always remain the importer. So the importer is the real plaintiff, so to speak. And it's only by virtue of the declaratory judgment procedure that the fishing company can become the pretend plaintiff. So we're going to analyze whether there is subject matter jurisdiction over these cases exactly the same. So the answer to this hypo, to this multiple choice question, is still A, for exactly the same reason. We did get into removal of cases from state court to federal court on week 2, and that extended into week 3. However, I have a removal video that I think probably covers most of what we did. So once again, I hope that this was helpful. Have a great day or a great evening. Thanks. Bye.